welcome back to the Abraham Watkins podcast. My name is Jeffrey Atkinson. I'm the social media marketing manager here with Abraham Watkins. I'm here with newly promoted partner, Lena Laurenzo. How you doing?
I'm doing well. How are you doing, Jeffrey? It's good to be here with you.
I'm good. Well, how does it feel to be a partner now?
It's very exciting. I'm very happy about this new chapter and, still overwhelmed, still surreal, but at the same time, very excited.
And what can we expect from partner Laurenzo moving forward?
Partner Laurenzo does not intend to slow down one bit. It's taken a lot of hard work to get to this point, and I intend to continue that hard work for our clients and keep trying to do our best as a firm collectively, and I'm happy to be a part of its history and do what we do best, which is elevating the game, doing the best that we do as trial lawyers, and looking forward to this new chapter.
Good to hear. So what we like to do with the podcast is start on your background and then move kind of forward. So Laurenzo, that is a synonymous name in Houston hospitality. Mama Nifa is your grandmother.
That's right. I was very blessed to have a wonderful grandmother. Mama Nifa Laurenzo is how Houston has come to love her, and to me she was just grandma.
Grandma. And how was it kind of growing up in that? Because, she's kind of famous in Houston.
Growing up, I knew she was a big deal, but not in the way that I've come to understand it now. And so I was very proud always to have her as my grandmother, and very proud of the symbol that she became for the city of Houston. The word hospitality in that kind of industry, she kind of gave it a certain level of warmth, earnest hard work that wanted to put good food on the table for people, no matter where you're from. And, the love that she brought into the restaurants that people said that they could feel every day, it was no different. Being her granddaughter, being family to her, that love that she shared was very special. And obviously a very powerful woman, business-wise, and a force to be reckoned with in her own right on that way. And so it was, my parents are wonderful role models, but having also a grandmother that was such a phenomenal person, a phenomenal human being that made a difference in people's lives, as well as being a successful entrepreneur. It was I was awestruck of her throughout my life, and I do hope that I make her proud today as a trial lawyer, even though I'm not in the family business, that I'm trying to hold up the Laurenzo name in my own way.
Well, speaking of family business, your uncle, not to be outdone, created El Tiempo. How did that kind of come about, and how was there a little friction there, the two rivals, or everybody loved it?
No, so anybody who's done a deep dive enough into Houston industry knows that Nifa's was kind of the name in the Tex-Mex game for a couple of decades until the 90s hit, and things kind of took a turn with the business. And while that ended up taking more of a downward turn, El Tiempo kind of rose from the ashes in that sort of respect, where my uncle and my oldest cousin, they had this idea to start El Tiempo, and my grandmother was fully supportive and wanted them to continue success in their own way, and it still has the name Laurenzo's there above El Tiempo. So, and of course there's the restaurant called Laurenzo's too, that's a part of our family. So, and both of them are ways of carrying forward our family tradition and hospitality, but also still kind of pushing the envelope, both on trying to do good things while being in a good business. And so I'm very proud of the family history that was carried on by my uncle and by my cousins with the El Tiempo restaurants and other restaurants that have followed since. So no friction. If anything, it was kind of a different new path forward for our family in that industry.
Great. Anybody who wants to know that crab enchiladas are amazing.
Actually the crab enchiladas, I will say they are fantastic. It's not always my go-to order, but someone kept recommending it to me. I'm a creature of habit, eating at my family's restaurants. I don't know how I wasn't 300 pounds growing up as a kid, but I had my go-to dishes, and people just all over kept recommending the crab enchiladas, and they are no joke.
Yeah. What is your go-to meal?
I try to mix it up a little bit, but you can't go wrong with the beef fajita tacos and a margarita on the rocks. Something about that is just so classic to me, and not when I was a kid, obviously, margarita aside. But now it's having the beef fajita tacos with a margarita on the rocks. Can't beat it.
So how did you separate your life, not going into hospitality, not following the family business, but wanting to go into law? How did that kind of come about?
You know, I never grew up thinking I was going to be a lawyer. I knew that I wanted to do something different than hospitality as far back as I could remember. You know, when I was a kid, if you asked me what I wanted to be when I grow up, it would be a basketball player. It would be a heart surgeon. It would be almost anything else except the restaurant industry. And not for any other reason except that my grandmother and my parents were a big proponent of education. And you know, the restaurant business is difficult. It is not for everybody. And even if you were born to do it and you have all the right tools and resources and talent, it doesn't mean it's always going to work out. But I knew I wanted to do something, get as much education as I could, and have options to do what I wanted to do, that I think whatever was going to be my calling, to help people. And I hadn't found my best channel to do that until I ultimately came to work at Abraham Watkins as a file clerk. And I also have a little bit of a history with personal injury law as being a plaintiff myself in college as well. So I had no plans of going into law school except to continue my education because that mattered to my family. None of my siblings, my brothers and my sister, they're all successful in their businesses, and none of them are in the restaurant industry. And it's kind of that same thing where we were all told, hey, the options are there. Go be what you want to be. Find your calling and get the education you need to do that. And I just happened to do that in my own way and going to law school and being the first lawyer in my family.
Okay. So you said you went to law school to continue your education. Was there a single event or person that you spoke to that said, hey, go to law school versus going to medical school, being a dentist, being a veterinarian? Something, I know further education is very important in your family, but what was there a specific thing that made you go into law?
Yeah, so there was a couple things that kind of put me, I kind of say that the yellow brick road was being paved as I was literally walking it. So I graduated college with a degree in psychology, and my full plan when I graduated was to go to graduate school and go do more psychology and ultimately do experiments on college students for the rest of my days, whatever my focus would be. And so I had that plan in place, and I actually had my ongoing personal injury lawsuit at the time when I graduated from undergrad. I was hit by a drunk driver when I was becoming a senior, and that lingered for a couple of years. And during that time, I happened to get a job here just by chance at Abraham Watkins as a file clerk. So,
did we have your case?
You did not have our case. It happened where I was in Lubbock, Texas, where the accident happened. So I had a Lubbock lawyer helping me through that. And so while that was kind of going on, and being exposed to the legal process for the first time in that way was a very, very unique and eye-opening experience, that there are times that people go through these difficult times in their life and they need help. And especially during the legal system and going through that process, you need someone to help you navigate it for the best results for you. And so when I joined this law firm, I learned that's exactly what they did. They happened to be the same lawyer that I actually had already hired, and they were helping people daily in all sorts of serious and catastrophic injury cases. And I will be honest, I had a lot to learn as a file clerk. I didn't know what pleadings were, discovery. It was a new language, foreign language, and I didn't love it at first because it was just so much to learn at the forefront. But within a couple of months of being a file clerk, I ended up meeting with all of the partners here at the law firm and asked what it took to get to law school, because I saw them doing good work. I saw them getting great results for their clients. I saw them doing something that I thought I could do, being a trial lawyer. And so I was inspired by the people I called mentors at the time and my bosses at the time. And so those kind of put me on the path to going to law school. That ended up being the right path for me.
And so what led you to Abraham Watkins as a file clerk? Was somebody working here that you knew? Did you just apply to different law firms and Abraham Watkins gave you a call? You
know, so this is sort of where my past history and being a granddaughter of Mama Ninfa kind of intersected with my future career. And so Benny Augusto Jr. at the time, he was MABA president, I believe. And at MABA, they were giving away scholarships, and they would usually select a prominent Hispanic or Latino person to honor with that award. And that year, I had graduated undergrad. They were honoring my grandmother. Benny chose my grandmother to be person who the honor would be in her name. And so my whole family went to be there in support of my grandmother's being honored that way. And a couple of partners said, hey, they knew who I was. Based on our past history, I was coached by Randy Sorrells many years ago in sports growing up, and Benny Augusto, I've known him for years too, but so they just happened to know of me and asked if I was looking for a job because they could use a file clerk. And so it really was just a complete happened chance, and that they offered me a job or encouraged me to apply, and I got the job, and kind of the rest was history after that point, where that was my first job in the legal industry as a file clerk here at Abraham Watkins, and it's pretty crazy that here I am now a partner at the same firm.
From the bottom to the top.
I don't think it's more full circle than that, really.
So what made you, was speaking to Benny, what made you decide to be an actual attorney versus just staying a legal assistant or becoming a paralegal?
Yeah, so once I realized that I was interested in law school, I wasn't sure if I was smart enough. I wasn't sure if I could take the test that you need to take to get into law school. I didn't study anything about law school in undergrad, so I had a lot of questions that I wanted to make sure, hey, am I wasting my time going into this career? And luckily, after speaking with Benny and with others, is that I had all the right things in place. Having an undergraduate degree is what you need. You don't have to be a political science major or a pre-law kind of person. I had no idea. I had no guidance except at that time to learn, hey, you can do it. You can do it with just an undergraduate degree. Go take the LSAT, which has changed now, the requirements to get into law school, but at that time, I studied and got as good a grade as I could. And, I was very much looking forward to the challenge of going to law school as well at the same time. So I did what I could to prepare myself for law school by taking the time here as a file clerk and then ultimately becoming a legal assistant, kind of learning how litigation works, going to the courthouse and watching a couple of trials and seeing kind of how how it's made, how the sausage is made. But it only helps you so much in law school. You learn so many different areas of law, and so law school itself was a challenge, but for the encouragement that I had from Benny and other people that were working here at the time, that if you work hard and you've got a brain between your 2 ears, you can do it, right? It's just whether then you have the natural talents to go into law and pick the right area for you. And I knew I wanted to be a trial lawyer by watching these guys go do hard work in the courtroom.
And was Benny the one that kind of pushed you towards South Texas?
Absolutely. I can't say that it was hard getting recommendations to South Texas from Benny and from other partners here that were graduates from South Texas at that time. They helped me understand that it is a great school, and I could not be more grateful for it to be put into my thoughts as a potential law school to go to. I had no idea what were good schools, what was the right school for me, and from their influence, South Texas was absolutely the perfect fit for me, and I think that's the reason why I have become not just a trial lawyer in name, but in practice.
Staying on your background, coming forward, you've gone to law school, you've come to Abraham Watkins. Before Abraham Watkins, you had your first trial. I believe it was $17.7 million wrongful death. Can you kind of share on that verdict and how it kind of shaped your career going forward?
Absolutely. That was a life-changing event for me for sure, because I got to participate in a complex wrongful death trial for my very first trial. And I had only been sworn in as a lawyer less than 6 months at the time. So that's one of those reasons I say that I'm grateful for my first firm that gave me that opportunity, and they put that trust in me in a very big case. And so essentially I was asked to help the lead partner on the case as co-lead counsel. And I was in charge of opening statement and handling a bunch of the damages witnesses and the plaintiffs to prove our case at trial. And so it was a team effort to do that, and that was absolutely, that has shaped me from the beginning of my career, is that there are some cases you can do solo and you can do justice for your client. But there's other times where you're going against some of the best lawyers in the country, some of the biggest companies and corporations that know exactly what they need to do to protect themselves. And it is always in your client's best interest that if you can collaborate and have a team going forward in those sort of big situations, that's going to give you the best chances of a good result. And so there was a team effort that was put there with Vuk Vujicic. He was taking lead on liability, I took lead on damages, and we were able to come to that verdict after a 2-week long trial. And so it was, I'll never forget the feeling of standing in that courtroom with either the jury crying with me and with my plaintiffs, my clients hugging me after that trial because they felt that they had been heard when the jury came down with their verdict, that justice had been reached in that moment. My mock trial coach was actually in the courtroom when I gave my opening statement, and I'll never forget that when I turned around and I got a thumbs up from him under the table after I finished my opening statement. So it was an incredible experience that ratified or confirmed this is my calling. I'm supposed to be in the courtroom fighting for the rights of my clients. And so having such a big trial to start with, people joke that it's only down from here, right? You've gotten a verdict that is higher than any verdict I've ever gotten. I've done this for 30 years. I don't see it that way. I see it as I was lucky to be given that opportunity. I worked hard to be given that opportunity as well, or at least be considered for it. But it just shows me that anybody can do this, I think. As a female, as a young female Latina lawyer, the first in my family, I'm not following anybody's footsteps but my own. And trying to just take in what from my mentors and learn from them in the courtroom. And it was just, I'll never forget how the excitement I felt when the jury started calling out the numbers. It's like I'm always chasing that feeling. It's like justice was made in the moment, and now I'm always chasing that feeling.
Okay. Well, switching gears a little bit, you just finished trial last week.
Yes.
Came to a confidential settlement. There was no jury verdict. What can you share about the trial that you're able to speak on, and also why would you choose to settle the case mid-trial versus waiting for a jury verdict at the end? What kind of goes into that thought process?
Sure, yeah. So that was another big case that we just settled recently. I was trying that with Benny Augusta Jr. and as well as other attorneys here, Disha Roy and Edward Keenan. And so I was grateful that we were able to settle that case. We put a lot of hard work into it. And so what I can share about this type of case is because it's public record, there's a lawsuit that's been on file. We went 4 days into trial. So there's stuff that's just out there about this case that people can just learn. And really what happened is that the trial was against a valve manufacturer. The company was called Zomox Corporation, that we alleged and offered evidence at trial that they failed their responsibilities as a product maker and also as a product refurbisher in a few ways. We focused and offered evidence regarding, we feel that they didn't provide enough warnings or instructions with their product, that they could have designed it better, and that also that when they refurbished this valve, which is basically making it like new, right? You sell a valve, it gets put into harsh working conditions, you need to spruce it up, you need to get it cleaned out and maintained every so many years. And so the manufacturer did that for this valve a couple of times too. And so when they refurbished it, we said they failed these same sorts of things, that they should have provided more information, more instructions and warnings about a particular known hazard associated with this valve, which is that it could come apart while it is loaded full of chemicals, when it is literally in a pipeline in use, not just being taken out for maintenance or being repairs and things like that. But that we say that there's this gap in their instructions and warnings that for this known use, using valves to control the flow of chemicals, but why can it come apart when you're trying to take equipment off of it? And so essentially we offered evidence about how they knew about this sort of hazard for decades and failed to address it. And it was very a contentious trial with very excellent defense counsel doing their best they can to offer evidence that the company was not negligent, that they refurbished it properly, that they didn't have to warn, or that they gave enough warnings, right? And their focus was, of course, on the chemical plant that had this valve, and whether there was training or policies and procedures that should have been followed to prevent what the basis of the lawsuit was. A massive chemical release came out of this valve when some of the wrong parts were removed mistakenly. And that's happened in the past before, and that was a big part of this case that we had been fighting throughout all of the public records, that what role this valve maker had in being able to prevent this. And so coming down to the 4th day of trial, we've been working hard, we've trusted the process, we're expecting the jury is listening, and they sure did listen and gave us the attention on a very complex case with good lawyers making good points for both sides. But at the end of the day, as much as I love being in the courtroom, as much as my colleagues and partners love being in the courtroom, because that's what we do best, there are real people that we are representing. And you are trusting 12 members of this community to get it right. And they don't always get it right? You are rolling the dice when you go to trial. Except at the craps table, you have a couple dice, right? Here you have 12 dice, and you're hoping they all land on the same face, in your favor. And the more complex a trial is, the more those dice can go different ways, right? And so there is no guaranteed result when you go to trial. And any lawyer who tells you differently, they're selling you something, right? No one can predict what can happen at trial and what that jury is going to do when you give them the case. And cases that go to trial, it's because they're not perfect, right? Cases normally settle. And if they go to trial, it's because both sides see potential to win or to have a better outcome than settling. But we pushed this case to a point, both sides, that we were able to finally find a compromise that made sense to both sides, a confidential compromise, of course, and that's a way that we're able to take care of our client's best interest in that way. Is I'm not trying to gamble with your money. If there's a way that I can get you a really good result that's not dependent upon 12 strangers and dependent upon potentially the courts of appeals or the Texas Supreme Court after that, because if we win and get a big verdict, that doesn't mean the fight's over. And I'm trying to bring closure to these clients' lives, not prolong these chapters of a very difficult time in their lives. And so that's something that we have to balance, is we have to make the right call. And I believe we made the right call in this case because we're able to bring some compromise but some closure for our clients, as well as with some compensation.
Okay, so for those people at home, what is different about verdict versus settlement? So my understanding is settlement, sign some papers, the defense sends a check, and 30 days, 45 days, case is done. Verdict, what can kind of happen? It can kind of get a little dicey, right?
Right. So that's exactly right. So a settlement, it's finality. You have a compromise, and hopefully everybody has some sort of satisfaction out of that compromise. You sign an agreement and make sure that you're not waiving rights you're not supposed to be waiving, but that it's bringing everybody closure. And that closure for our clients is normally compensation and making sure their medical bills are resolved and everything like that, so that they can move on and stop the lawsuit if there is one, close it, shut it down, and move on from there. Verdict means that you've taken a case all the way to trial, and either a judge or a jury has actually decided the facts of the case, who wins, and if there is any compensation in our sort of world during personal injury law. And so when you have a verdict, it depends who wins. There's a winner, right? Someone has either said that the jury has either held somebody accountable for something that's happened or a wrong that's happened, or they say there is no negligence here, right? We find for the defendant. So it can go a few different ways. But at the end of the day, if it turns out well for us, where we get a large verdict or a fair verdict for our client, depending on the stakes that are there for the other side, they may want to go change law. They may not want to pay that much money because they think that the judge got it wrong or that the jury got it wrong. And so the verdict is actually not always final, and it can be signed in something called a final judgment, and that's the time where you're trying to collect from our perspective. If you win, the judgment stage, when that's been signed, that's the time to try to collect the money from the verdict that you've gotten for your clients. But if there's a verdict and a judgment that gets appealed, that gets challenged based on a legal basis or some other reason rooted in the law that can challenge that verdict, that's something that is a part of that verdict stage is that there is not normally finality. It's usually going to get fought in the upper courts. And that's another territory of legal battles that us plaintiff lawyers that we have to be mindful of, because the courts go certain ways. They review these trial verdicts and they decide whether they stand or whether they get sent back down to go for a second trial, or they decide, you know what, that verdict doesn't stand and this is so messed up, and for whatever reason, you don't even get to go to trial. Case is over. And so there's a lot of different ways that a verdict can go, and that sort of potential there, especially in the case of larger size, that's a high risk that everybody has to analyze and make sure that they're making the best decisions for their clients and their best interests.
And that can just prolong the whole ordeal, right? Because this particular event happened 3 years ago, 4 years ago?
Right, exactly right. And so the appellate process, unfortunately, it's not a speedy process. It usually takes about 2 years to get a decision from the appellate courts if you're taking a verdict up for them on some sort of challenge. And so, for example, my very first jury trial, it was appealed for having a $17.72 million verdict. Somebody wasn't happy about that, right? And so it got appealed, and it took over 2 years for the appellate courts to decide a legal issue in that case. And then it ended up being taken up to the Texas Supreme Court, which then kind of the legal issues were put to rest. And unfortunately, the Court of Appeals didn't go our way. And so I have that experience of knowing that with these sorts of high stakes, big cases that we handle, we have to know that it doesn't just end in the courtroom down the street on 201 Caroline, which is our trial court. It could end in Austin at the Texas Supreme Court. And so we have to always have this ability to look ahead, that advising our clients in these moments, it's not always just about the facts of the case or, you know, how injured you are. That's definitely a part of it. But it takes an experienced lawyer to understand there's a myriad of legal issues that can affect your case and affect the best results that you can get for your client. And I think every lawyer has to take that responsibility very seriously so that they always lead their clients to the best possible resolutions in any of their claims.
Okay. And in this trial, valve went bad. The defendant knew the valve could go bad. They've known that. People got hurt. What was the defense's argument during trial? Not our fault. What kind of?
Right.
What was the defense?
Right, and so, you know, we have some things to be mindful of when we talk about this case, but what was publicly articulated by the defense was that that the chemical plant that had this valve, they're the type of user that's always using these valves, so they should know how to use them. It's kind of the end of the day, one of their legal issues, a sophisticated user. That, hey, the chemical plants are the typical kind of people that are going to use valves. They know how to open and close them. They know how to take them in and out of the line. And so when you're taking equipment off of it, shouldn't they be capable to do that? Or any other contractor that's in this industry of chemical plants and refineries, of turning nuts and bolts, that they should also be considered in the know of how to properly work their valve. That's what they would say. And I understand their defense. It's rooted in Texas case law. And so it's something that we had to be mindful of in making sure that when we're presenting evidence is how do we explain that the hazard in this case that we say that the valve maker knew that was not commonly known to the industry and how to avoid it. That's kind of, we were trying to thread that needle, right? And it's a difficult needle to thread, but that's part of a way that we were trying to counter that defense. But that was the main defense, is the chemical plant has policies and procedures. They've got people who've been doing this for years, and they should have been the ones to be able to prevent this by their training, by their policies. And the company, you know, also defended the case that that they did provide warnings, even if they thought that at law they shouldn't have to provide warnings or instructions. They said all the information was there in the manuals that the chemical plant had access to or had in their possession. And so it's a very fact-intensive analysis when you're going through their defenses and what we say happened too, right? So it was not a surprise what they were defending the case on. We knew the whole time of what the facets of the case were, depending on whose shoes you're looking at, what happened that day. And so, and I think that's something that every trial lawyer has to do when they're preparing for trial is all right, I know what my case is, I know what I want to say about my case, but what is the defense going to say about this case? And is it believable? Is there credibility in the facts and the evidence? Do we have a witness that's just going to carry that defense home for them that's the jury's going to be able to relate or understand? So there are other nuanced defenses that they were offering, but the defenses that they offered, they were not, they were strong defenses, being articulated well to the jury. We had a Q&A session with the jury afterwards, and they thought that both sides were making great points for their sides, and they hadn't actually had their minds made up about who was quote-unquote winning. So the defenses had some viability too, and that's why they offered them.
Okay. And as a result, we did reach a high confidential settlement.
I will not characterize what the settlement was, but I will say that it was a fair settlement and a confidential one at that.
Okay. And this was not the first time you and defense got together at trial. The event happened years ago.
Right.
You've known the defense team, you've met with them multiple times, but we couldn't reach a settlement. What are the steps for those victims, or I guess future victims, so they kind of know the process? What are the steps of before we get to trial? How do we get there? There's mediation. I know in some cases there's arbitration. Was there arbitration possibility in this one?
Yeah, so this event happened in July of 2021, so it has over 3.5 history, and actually the Valve defendant was only brought in about a 1.5 years ago.
Okay.
And so, but in any event, it's still a long enough life of a case that we had a lot of work against the opposing counsel, and really when it comes down to the life of a case, most cases do settle. And most courts expect you to at least try to come to some sort of meeting, like a mediation, which is different than an arbitration.
Can you explain those differences?
Absolutely. So a mediation is something that almost every single case has to go through or should go through before it ever reaches trial. Courts require it, and it's usually a good practice to consider it too, for the same reasons that I was discussing before. Trial is, nothing's guaranteed when you go to trial. But a mediation is essentially where the parties involved, both on the plaintiff side and the defense side, that they select a neutral third party called a mediator. And what they do is they schedule a time to meet in kind of a neutral zone, mostly in an office, but with the capability of Zoom these days, sometimes we can do this remotely. But essentially we're having a meeting where you have everybody for the plaintiffs and their legal counsel, everybody for the defendants and their legal counsel, and they're meeting with the assistance of the mediator. And the mediator is assisting the negotiations process to help them identify facts that are good for each side, and any agreements that the parties can reach about the case, right? And to try to help each other see the risks that each side faces moving forward, all in an effort for everybody to look at the case and try to make a reasonable decision about compromise. Because there's our hopes and dreams of what we think are the best numbers that our case is worth, or what we think a jury can give us. But if we're getting to trial, like I said, there's reasons for it. There may be some things and facts about the case that you hope the jury is not going to buy or be interested in, but the other side is very interested in it, and they know it can affect the value of your case. So the point is almost to make a semi-business decision about compromise in the case, trying to remove some of the emotions from it and trying to understand that both sides have a set of facts to deal with that's governed by the law, and that neither side can predict what a jury's going to do. So let's try to look at this realistic and try to come to a resolution. It's usually by agreement between the parties that you go to mediation, if not also court orders sometimes. But the choice to settle at mediation, it takes both sides. Everybody's got to come to the same agreement, so there's no forcing of settlement on anybody. It is a confidential process, so things can be spoken about freely about the case without it being held against you. And really most cases do resolve in settlements at that stage. I think about 80% of cases that do go to mediation do settle at that first mediation, although there are some that require a second or third mediation to get the parties really in the same ballpark and talking the same language about what's a reasonable compromise. But an arbitration is completely different than mediation. It's actually more similar to litigation, where it is an actual kind of proceeding where the parties have either agreed by contract or otherwise have an agreement to proceed with a claim in front of an arbitrator. So in our litigation world, we answer to juries or we answer to judges. In the arbitration world, they answer to arbitrators. And so it's a completely different process that doesn't have an appeals court or anything like that. And it's something that I fortunately have not had to do much arbitration in, because that means my clients have had the rights available to exercise their Seventh Amendment rights and get a right to a trial by jury. And so I firmly believe in those rights, and I think that protects our injured workers more so than the arbitration process, just in my experience.
Okay. So, been going back and forth with defense, mediation, or arbitration. You know you're going to trial. You have a specific date. When do you start preparing for trial, and what are the specific steps that go into preparing for trial? Because the whole trial is a process, right? So you kind of have the gist of, you know, opening statements, closing arguments, evidence, but what kind of goes into your preparation for trial?
So if you were asking me that question versus other trial lawyers, I think everybody has a different process. But I'm literally thinking about trial the day I sign up a case. I'm thinking about my opening statement. I'm thinking about the best facts of my case from day one. And I think every trial lawyer needs to operate that way, because if you have the mindset that trial is possible from day one, then you're doing everything you can to make sure that you're investigating the case thoroughly and setting yourself up for success at trial in the best way that you can. But when trial becomes very real, meaning we've got a trial date, we're not settling, no interested in settling at this time, we got to move forward, because that's the only way, is moving forward towards a resolution. And so my process involves a lot of hard work. And anybody who is taking their trial work seriously, they don't just walk into the courtroom and just start talking about whatever they want to talk about without studying the evidence, studying depositions, looking at the documents and the evidence, and trying to piece together the exact same puzzle that you're going to present to the jury. So preparing my opening statement, for example, I had been agonizing over that for weeks, because that's my first chance to tell the jury our story, uninterrupted. And so I take weeks to draft my opening statement, because I'm looking at facts and I'm talking with people about themes, and it's trying to come up with the best and concise statement about why we win from the very beginning. When I'm talking with colleagues about preparing for the direct of a witness, it takes me knowing my case and knowing my clients. If I'm presenting a client, for example, I can ask for help from other people, but I know my client best. And so I spend time with my client. I read their medical records. I read their depositions and their statement. I meet with them to make sure that, hey, I'm comfortable with the courtroom process and I know how this goes, but this isn't your normal life. And you're expected to share your story with 12 strangers of this community, open court, and in this case, our case was live streamed with hundreds of people watching. And you imagine that some people have that public speaking nerves, right? And I still get them, but I've learned how to channel that and to make myself better. But my clients need that boost of confidence from me, that they know what the truth is. And I'm just there to help them get that truth out. But in order to understand the truth, it takes all that years or months of hard work of studying the facts and understanding, okay, what is the truth? And what do we need to make sure comes out of your testimony to make sure I'm checking the boxes and proving your case, as well as helping you connect with the jury and with the courtroom so that they understand what you're saying is real and that it's credible. Because the jury can disregard what you say if they don't think what you say is from the heart or believable. And so no matter the skill that I'm preparing for a trial, it takes weeks, if not months, to do the work right. The bigger the case, the more months of work that you have to do. So we have deadlines, internal deadlines, months ahead of trial to make sure that we're never losing sight. Whether we're going to mediation or not, we're never losing sight of when the trial date is, so that we are checking our boxes, making sure experts are in line, making sure all of our best evidence has been given to the other side, making sure no stone has been left unturned in the final days of investigations, to make sure that when we get to trial, we've got the best facts that we can put forward, and we know our case better than anyone else in the courtrooms. That'll allow us to be flexible, think on our feet, and argue our case to the courtroom as best as possible.
Awesome. Well, I'm gonna kind of start winding down and get you out of here. But
Sure.
you've been selected to Rising Stars 8 years in a row. What does that kind of mean to you? Because that's a pretty big deal to be selected to Rising Stars in the first place, and then 8 years in a row. What does that mean?
It's incredible, really. I'm honored and humbled that I keep getting this recognition from super lawyers as a rising star or as a top female lawyer or top 100. That my hard work is something that I live with on a daily basis. Right, that's just a part of my life to give my clients their best chance at justice. But when you have something like super lawyers that I saw recognizing my mentors and my bosses when I'm a file clerk, when I see that this is a recognition that they are capable lawyers, that they're good lawyers doing good work amongst the elite, right? That's it's weird. At the same time, it feels great to be able to say that I'm a super lawyer rising star for 8 years. It's not something that I expected, especially the first time it came. I've been nominated ever since my first year as a lawyer. And when I got it as my first year as a lawyer, I thought, oh, this is a fluke. This must be because of that big trial I had that went well for us, but surely it won't happen the second year. But I'm just going to keep working hard. And then it came the second year and the third, and then it hasn't stopped since. And it's just, if anything, it's motivating me just to not stop. I have to keep going. I don't know how many years that they're going to give me that award, but the more I can try to do it, as young as I can say as a rising star, you have to be so young, there's so many years of practice. I'm going to try to tap out as many years that they can give me to prove it to myself that I really have found my calling, and two, to prove it to others that really someone like me never had a thought about being a lawyer, had all the doubts in the world about whether I'd be good at this, let alone whether I fit in. The sky's the limit. The sky is the limit for anybody else who has any passion to do good for people and believes that they have the natural talents in the practice of law. And so hopefully I make 9, 10 years, however years that they're able to give it to me. But even if they stop, I am so blessed and humbled that I've made it at least 8 years.
And for the young attorneys out there, especially young women, what advice do you have for them for becoming accomplished personal injury attorneys?
So I'm a big supporter of women and Latinas and minorities to pursue the field of law, just generally, if they feel that there is something there for them. As far as being a personal injury attorney, when I think about what makes me a personal injury attorney and what I think are my best qualities, I think is something that hopefully other Latinas, other young females will consider to be useful qualities for themselves or traits to try to strive for, which is you have to put in the work. You have to be confident in yourself that you can do this with enough hard work and relying on people who have been there before. And being open to learning every single day. I learn every single day on the job. And it comes from this internal desire, this competitive desire to always be better. And so I don't know if me being a female athlete growing up helps bring out this competitive edge, but if you're a female or a minority looking into the personal injury area of law, there is a natural competition there. And you are there to beat your opponent, both as best you can under the facts and the law that applies so that you can get the best results for your clients. And so women, I think, need to be ready to work hard and be aggressive for their clients. But there's also this natural ability and quality that women have that is absolutely a strength that I hope that all young ones would consider, really emboldening in their everyday lives, which is we can both be strong and soft, that we can be aggressive but caring and motherly at the same time. Lots of male attorneys can have a touch too of being both aggressive and hard and being appropriate for the circumstances, being a little bit more gentle in their touch. But I think women have an extra edge in personal injury law where we have clients that we can relate to as females, as mothers, as sisters, that we can coax trust out of our clients in a different way, that they can tell us their problems and why this is such a difficult time for themselves without feeling judged, without being treated less than. And so I encourage young females, young Latinas, minorities to work hard, to seek mentorship, and to really look at your internal qualities and traits. If you're competitive, if you are someone who's not afraid of public speaking, if you're just not afraid to do something and learn something new every day, then that's the type of lawyer that you should strive to be. You should strive to be a personal injury lawyer.
And how do you find a balance? You have a family, you love golfing, and you said you're an athlete. How do you find a balance between becoming a partner now and having a very balanced life between the family and your career?
So I get asked that a lot, and it really is, it's an ebb and flow of a balance, right? There's some days like going to trial recently, and such a big trial, it required a lot more time, and so that means there was less time golfing or doing things that I like to do for fun or spending time with my family, but the sacrifice is worth it to do the best that I can for my clients in those moments. But that's not like how it is every day. There are many days of the week that I'm still able to pick up my son from school. I'm still able to take my wife and family to lunch or go to the zoo. And so what it is I have found a way to use the clock to my advantage as much as I can. And so there are some days where I get to balance it more in favor of hobbies, of networking, of being around people or being with my family. And then there's days where I have to balance working harder because that's what the job requires. And so it's taken years to understand that no 2 days are going to be the same, and being, okay with the process, that not every day is going to be the same. There's sometimes you're going to be busier. There's sometimes you're going to have more free time, and it makes you cherish those free times just a little bit more when they come around. And so I'm blessed to have the trust of my partners and the people that work here, that they know I'm working hard. And I don't necessarily have to be here every moment of the day to prove that. The proof is in the results, right? But I am blessed to have a lovely wife and family that are supportive of me, that they understand that there are times I just have to go to bat for my clients and it just takes a little bit more time out of the day. But I have that trust, and I don't want to ever ignore that or not be thankful for that. So I'm thankful for the ability to have the trust of my partners, my colleagues, as well as my family, so that I'm doing exactly what I'm supposed to be doing and balancing my life and my career.
Well, partner, Lena Laurenzo, thank you so much for coming on with us today.
It's been a pleasure.
Thank you guys.